Hello everybody. Today we'll be discussing about the second part of law of contract, which is contract of bailment and pledge. So to introduce bailment and pledge are special kinds of contracts. It is mentioned in the chapter 9 of the Indian Contract Act of 1872. Bailment means delivery of goods from one person to another for some specific purpose, and pledge means delivery of goods as security for the payment of debt or performance of a promise. So we'll look into it in detail as to what is the exact difference between bailment and pledge. We'll be dealing with the provisions that come under bailment as well as pledge in detail. So in the first session, we'll be dealing with the principles, the aspects that come under that is related to bailment. So bailment is defined under section 148 of the Indian Contract Act of 1872. And to specifically define bailment under what is given in the Indian Contract Act is like how it is. Section 148 of the Indian Contract Act 1872 defines bailment as the delivery of goods by one person to another person for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. So if you notice in this definition itself, there are certain highlights to the concept of bailment. So that forms the essentials of a bailment. In fact, there are certain key points which comes under bailment that we'll be discussing in the coming slides. Before that, let me introduce you to the two main parties of the bailment. In bailment, person delivering the goods is known as bailer, and person to whom they are delivered is called bailee. So there has to be two people. One is the bailer and the second one will be a bailee. So to give you a typical example of a bailment of a contract, is a very common contract or is a very common sale that happens is between a tailor and his customer. The customer is considered to be the bailer, who would be giving his cloth to the tailor to get it stitched through the tailor. Okay, so the tailor in this situation will be the bailee. So the tailor would get the cloth modified and make it into a shirt which is fit for the bailer. So what he's doing is the bailer is delivering the goods to the bailee, and it'll be for a specific purpose. And once the purpose has been accomplished, the bailee is supposed to deliver those goods back to the bailer. Okay, so that is the typical example of a contract of bailment. We'll look into detail as to what are the essentials of bailment in the next slide. Essentials of bailment. One of the most important essentials of the bailment is the delivery of possession of goods. If there is no delivery of possession of goods, what happens is bailment becomes invalid. Delivery of possession is of two types mainly. Without delivery of possession, bailment becomes invalid. So delivery of possession can be of two ways. In actual delivery, the bailer delivers the goods to the bailee. There is a physical delivery that is happening between the bailer and bailee. But under constructive delivery, which is the second type of delivery, there is no actual transfer of goods from bailer to bailee, but it is doing some act which has the effect of putting the goods in the possession of the bailee or any authorized person. So this will be typically like probably handing over the keys of a go down where the goods are kept. So that is like, transferring the possession of the goods. So suppose the bailer's goods are kept in a go down. So the bailer would not physically deliver the goods to the bailee, but instead what the bailer is doing is just handing over the keys to the bailee. So that is an example of constructive delivery, where not exactly the goods are delivered to the bailee directly, but it is like doing some act where the goods are transferred to the bailee. So there's a very famous case law to explain the concept of delivery of possession. There's this case law called Kalya Perumal versus Vishalakshmi. So Vishalakshmi, this lady, she hired a goldsmith, Kalya Perumal, and to get her jewelleries remade. So what she used to do is, she used to lock her jewelleries in a box which was kept in Kalya Perumal's shop. So, and she used to take back the keys. So eventually what happened was, somebody stole the jewellery, and she filed a case against the goldsmith, saying that the possession was with the goldsmith and he had to be held responsible for the act. But it was held that since the keys were in the possession of the lady, it cannot be considered as a delivery of possession. Okay, so this is a very famous case law which explains the concept of delivery of possession. So moving on to the next point, there has to be a valid contract between the bailer and bailee in case of bailment. So all the essentials regarding a valid contract has to be applicable with respect to a bailer and bailee. Without a contract, a bailment cannot become valid. Now the next point will be, the delivery must be for some purpose. So if there is no purpose behind the delivery of possession of goods, it cannot be termed as a bailment. So there are different purposes by which bailment can be done. So it can be for safekeeping, or maybe it can be for some repairs, or maybe it can be for some alteration. But then there has to be some purpose for which this transfer must be there. Next point would be, once the specific purpose has been accomplished, it is the responsibility of the bailee to return the goods back to the bailer, to the owner. Now, if this return must not be there, then it cannot be considered as bailment. So once the purpose has been accomplished, the goods have to be returned back to the bailer. And the goods here that we are talking about has to be movable goods and not immovable goods. They have to be strictly movable goods. So these are the essentials of a bailment. So if these points are not there, then it cannot be considered as, the contract cannot be considered as a bailment. Moving on, these two are the typical types of bailment that are there. These two are the two types of bailment that are there. One is gratuitous bailment and the second one is non-gratuitous bailment. Gratuitous bailment are the type of bailment which do not have any consideration passing from the bailer to the bailee. There is no consideration that transfers with respect to gratuitous bailment. It is out of gratitude. So basically, contracts between friends, family, which do not really have any type of consideration, they are known as gratuitous bailment. There are no typical conditions or clauses that are attached to such contracts. Once that, but then still there will be some purpose, and once that purpose has been accomplished, the bailee will deliver the goods back to the bailer. So an example for a gratuitous bailment may be, when you're lending your book or maybe your vehicle to your friend, and for some purpose. So if it is a vehicle that has been delivered, your friend is going on a tour, and he'll return it back to you once he comes back. Or if it's a book that you're lending, once your friend has finished reading the book, he'll lend it back to you. So that is a typical example of gratuitous bailment. Then you have non-gratuitous bailment, which has a consideration that is attached to it. So non-gratuitous bailment are the most the bailment which is again profit oriented, which has some type of consideration that is passing from bailer to bailee. So there are conditions, there are clauses that are attached to such bailment, unlike gratuitous bailment. Next topic is regarding rights and duties of a bailer. Now there are lots of rights and duties when it comes to bailer as well as bailee. Let us look at what they are individually. The first right is whatever faults that are there with respect to the subject matter that is being delivered to the bailee, all those faults have to be disclosed to the bailee by the bailer. Now, in case of gratuitous bailment, whatever faults that the bailer knows about the subject matter, only that need to be disclosed to the bailee. But in case of non-gratuitous bailment, since there is a consideration and there are conditions that are attached to it, what happens is it is the bailer's responsibility to examine the goods and see to it that there is no possible faults to the subject matter. So he has to do a detailed examination of the product or the goods that has been delivered to the bailee before the bailment contract is entered into, and see to it that there are no probable faults that are going to be coming up once the contract of bailment gets active. Now the next duty of the bailer would be reimburse extraordinary expenses of bailment. So if there is any additional expenses that is incurred by the bailee when the goods are under his possession, all those additional expenses or extraordinary expenses that is incurred to the bailee in order to maintain the goods, that has to be reimbursed by the bailer. Next point will be indemnify the bailee. When the title of the bailer is defective and the bailee suffers any loss due to this, then it is the responsibility of the bailer to indemnify bailee. Indemnify means to make good the loss. So if the bailee has suffered any loss due to this, then it is the responsibility of the bailer to indemnify that loss. The next point will be indemnify bailee in case of premature termination of gratuitous bailment. So in case of gratuitous bailment, the bailer can take back the goods whenever he wants. So even if there is any date or if there is any purpose that has been attached to a gratuitous bailment, whenever the bailer pleases, he can take back the goods from the bailee. That is how gratuitous bailment works. But at the same time, during that period, if the bailee incurs any expenses with respect to the goods, that has to be reimbursed by the bailer. So because there is a premature termination of contract that is happening there, it is the responsibility of the bailer to reimburse those expenses back to the bailee in case of premature termination of bailment. And it is the duty of the bailer to receive back the goods after the purpose has been achieved by the bailee. So once the bailee is done with the purpose and the bailee is trying to deliver the goods back to the bailer, it is the responsibility of the bailer to accept the goods back from the bailee. He shouldn't take much of delay. So as soon as the specific purpose is accomplished, he has to take it back from the bailee. Next, let us look at the rights of a bailer. So first right would be enforcement of bailee's duties. So all the time, a duty for somebody would be somebody's right. So the bailer has the right to see to it that bailee does his duties. So that would be the first right that the bailer has. First and most important right that the bailer has. Now the second point would be termination of bailment. So if there is any inconsistent use of the product, or if the product or the good is used in an unauthorized manner by the bailee, the bailer has every right to terminate the bailment even if it is premature termination. So that is a right that the bailer has. The next point would be to get back the goods lent gratuitously. So like I just told you, as far as gratuitous bailment is concerned, the bailor can get back the goods whenever he wants, even if the purpose has not been achieved or the purpose is not over. He can get back the goods whenever he wants in case of gratuitous bailment. Next right would be right to file suit against any wrongdoer. Now, if any third person or a third party tries to intervene and he tries to trespass into the duties of the bailee, then the bailor has every right to take action against this third person if he is not letting the bailee do the duty that he has been assigned to do. So the bailor has the right to file a suit against any wrongdoer as well. Now let us look at the rights and duties of the bailee. To look at the duties of the bailee, the first and foremost duty would be not to mix goods of bailor with his own goods. So as far as the bailee is concerned, he may have his own goods with him in his hand as well as the goods that has been delivered to him by the bailor. So he has to see to it that these two goods don't get mixed up. So suppose in case these goods gets mixed up due to some abnormal situation, then these are the remedies that are available to the bailor. Number one, if the goods are mixed with the bailor's consent, then both shall have proportionate interest. Now, if the goods have been mixed up and the bailor is aware of it, then everything is fine. If there is any profit or gain that is achieved because of this, both the bailor as well as the bailee, both of them will have a right or interest over what has been achieved. Next, if the mixing has been done without the bailor's consent. Now, if the mixing has been done without the bailor's consent, then bailee should bear the expenses of separation as well as damage arising from the mixture. So here, he is not telling or he is not informing the bailor that the goods have been mixed up. And if it is something that can be separated, okay, if it can be separated, then he has to see to it that it gets separated, and he has to also bear any expenses if that it comes up due to that separation. If something goes wrong with the goods, then that expenses has to be bear by the bailee. Then, without the bailor's consent and the goods are not separable, then the bailor has to pay. Bailor is entitled to get compensation from the bailee. So these are the remedies that are available to the bailor and when the goods are mixed up by the bailee. Next are the rights of bailee. To look at the rights of bailee, first one would be enforcement of duties of the bailor. So like we discussed in case of rights of bailor, it is the responsibility of the bailor to see to it that his duties are done, and it is the right of the bailee to see to it that the bailor does his duties. So it's a mutual thing, and that forms part of the first and most important point of rights of bailee. The next one would be if there are several joint owners that are involved in a bailment, then they have to it is the right of the bailee to listen to how the contract has to be made. So he needn't attend to every joint owner, or he needn't attend to every joint bailor. So whatever has been instructed to him as per the contract, he needs to follow only that, and he needn't personally be liable to each and every joint owner that is there. So the next right would be delivery of goods to bailor without title. Suppose a situation happens wherein the bailor does not have title over the goods and a third person is coming to claim the goods. Then it is the duty of the bailee to accept or to return the goods back to the bailor in good faith. So he needn't bother about the true owner, even if the third person is the true owner. He just have to return the goods to the bailor as per the instruction of the contract that he has signed with the bailor. The next point is right to file case against any trespassers. So if there is any trespasser that is intervening him or stopping him from doing the work that he has been assigned to do as per the contract of bailment, the bailee has every right to file a case against the trespasser. The next right would be bailee's right to implead. So if a third person comes and claims the goods, tells the bailee that the goods belong to him and not the bailor, then the bailee has the right to go to the court and stop the delivery of goods from the bailee to the bailor, and maybe act in favor for the new owner of the goods, the true owner of the goods. The next right would be bailee's lien. So as far as bailee's lien is concerned, in case the bailor do not give him the consideration which the bailee is entitled to, then the bailee has every right to retain the goods back with him until the dues have been paid by the bailor. So these are the rights of the bailee. Next, moving on to the second part of the session is the contract regarding pledge. So pledge is a special contract, but then to be more specific, we can call pledge as a special kind of bailment. So to define pledge, it can be defined as the bailment of goods as security for payment of a debt or performance of a promise. So that is the most the factor that differentiate a pledge with bailment. It is basically for the security of a payment. So when a person leaves the goods with another person for the purpose of as a purpose of security and takes some money from him, so that is a situation of pledge. So here there are two parties. So bailor in this case is known as pledger, or you can also call him as pawnor. And in second situation, the second party is known as bailee, and he is called a pledgee or a pawnee. So like in bailment, you have two parties here, pawnor and pawnee, or they can also be called as pledger or pledgee. So pledger is the person who is delivering the goods to the pawnee as a security for payment, and pledgee or pawnee is the person who probably lends money to the pawnor or the pledger. So let us look at the rights of a pawnor. So rights of the pawnor, this is a sole right of the pawnor is right to redeem. So on the repayment of debt or the performance of promise, the pawnor can redeem the goods or property that has been pledged before pawnee makes actual sale. So this can happen in a situation wherein the pledger does not repay back the money to the pawnee within the prescribed time, and the pawnee is making arrangements to sell the goods of the pawnor. Now, before the sale happens, the pledger or the pawnee has every right to get the goods back from the pledgee or pawnee until the pledgee or pawnee makes the actual sale. So there is time. So even if his time of repayment has exceeded, he can still make a claim back until and unless the pawnee does not make the actual sale. Now, once the actual sale has happened, then the pawnor or pledger cannot do anything. But then until then, he has every right to get reclaim back the goods that he owns, which is with the pledgee or pawnee. It's one of the sole rights that the pawnor has against the pawnee. Now let us look at the rights of a pawnee. Number one, most important one, right of retainer or lien. Unless and until the pledger or pledgee do not give back the money that the pawnee has lent to the pledger, they can retain back or have lien on the goods that is owned by the pledger. So until he don't pay back the dues that he's supposed to pay to the pledgee or pawnee, he can retain the goods with himself. The second right would be right to extraordinary expenses. Now, if the pawnee or pledgee incurs any additional expenses while the goods are in his possession, all those expenses can be claimed back from the pawner. Next right would be right to retainer for subsequent advances also. Now, suppose the pawnee or pledgee is making any subsequent advances or he's paying any subsequent money, giving any subsequent money to the pledger as loan, he can retain the goods that the pledger has already given him in the initial advance. He can retain it as long as the pledger do not give him back the subsequent advances as well. So there is no specific he cannot claim that the goods have been kept or pledged with you for the initial advance. The pledger cannot claim that way. So if there is any subsequent expenses that has been given to him, that can be also claimed by the pawnee. Next would be rights where pawner makes a default. So in case the pawner makes a default, there are 3 remedies that is applicable to the pawnee. Number 1, file a case and retain the goods that has been pledged. Number 2, sell the goods after giving proper notice to the pawner or pledger. And the third one, recover any deficiency arising on sale of goods on default. Okay, so these are the 3 rights that the pawner these are the 3 rights that the pawnee has against the pawner if there is any default that is made by the pawner. So, in order to conclude today's session, here we discussed 2 identical or somewhat similar type of special kinds of contracts, which is bailment and pledge. So, these are the differences between bailment and pledge. So, to sum up, we learned that as far as bailment is concerned, it is a transfer of goods for a specific purpose, but then as far as pledge is concerned, it is transfer of goods as security for repayment of debt. Now, in the second situation, as far as bailment is concerned, there can be a consideration which is present with respect of bailment. So, we learned 2 types of bailment, gratuitous and non-gratuitous. So, consideration may or may not be present in case of bailment. As far as pledge is concerned, consideration is always present. Now, in the third situation, bailee has no right to sell the goods in case of bailment. But as far as pledgee or pawnee is concerned, or in case of pledge, the pledgee or pawnee has every right to sell the goods if the pledger do not repay back the money that the pledgee has lent to the pledger. The next point would be bailee has every right to use the goods for a specific purpose. But as far as pledge is concerned, pledgee has no right to use the goods that has been pledged with him. And the last difference would be the purpose of goods would be for, say, safekeeping or for some alterations or for some repairs, etc. But as far as pledge is concerned, the purpose of goods is to act as a security of repayment of debt. So that's all for today's session. Thank you.